Joining us now to discuss, John Eastman, a former attorney for President Trump and a senior fellow at the Claremont Institute. John, good to have you with us.
Thanks very much, Vince. And yeah, that ellipses is a very significant one. It just proves that she knows that we're right because she's cutting out the language that alters her claim that only birth is all you need. And that language, of course, is and subject to the jurisdiction thereof. That's the critical thing. And they're all trying to act like that language isn't in the Constitution, but it is.
So what does it mean? So again, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. What does that important clause mean to you?
Well, and we don't need to speculate about this because the author of the language was asked directly about it. Will Native Americans, for example, be automatically citizens? And he said no, because they owe their allegiance to their tribe and only derivatively to the United States. This requires a complete jurisdiction, not subject to any foreign power. And so people who are born on U.S. soil to parents who are merely visiting, like on a work visa or a student visa, or who are here illegally and retain their allegiance to their home country, they're not covered by that automatic citizenship clause of the 14th Amendment. It's very clear. Supreme Court had said so in 1873. The leading treatise writer of the day said so, John Thomas Cooley. Opinions of the Attorney General in the 1880s said so. And it's only in the last 50 years or so that we've somehow developed this notion that those words really aren't in the Constitution.
So to your point, the 14th Amendment was ratified in 1868, but Native Americans did not become American citizens until June 2nd of 1924 on the passage of the Indian Citizenship Act. So if the 14th Amendment declared outright that everyone who's born here is a citizen, they wouldn't have had to grant citizenship to Native Americans.
That's absolutely right. And the million or more Mexican guest workers who were here in the 1920s that were repatriated to Mexico after the Great Depression and took with them the children that had been born here while they were here temporarily working, there would have been lots of claims that those children were citizens and therefore couldn't be removed from the United States. There's no such claim ever made. So the notion that this has been longstanding since 1868 is just a blatant lie.
So right now, as I understand it, if you're a diplomat to the United States, if you work for, say, the Russian embassy or something, and you have a baby while you're here, that child does not become an American citizen, do they?
No, they don't. But the folks that contest my interpretation of the 14th Amendment say subject to the jurisdiction just excludes the children of diplomats, and that's all it does. But everybody else, including temporary visitors, illegal visitors, what have you, they're automatically citizens. And that's where the fight is about. The issue, though, turns on what the drafters of that language termed partial or territorial jurisdiction. Obviously, if you're here within our borders, you got to comply with our laws.
Right.
Except for diplomats, because they're not even viewed as, they're kind of viewed as their own sovereignty wherever they go. So diplomats don't even have to comply with our laws. That's why they rack up parking fees in New York to the thousands and thousands of dollars. But everybody else is within our borders is subject to our laws. But they don't owe allegiance. They're not subject to the full and complete jurisdiction that this language of the 14th Amendment requires.
Well, even diplomats are subject to consequences if they flagrantly violate our laws. So you eject them from the United States. They become persona non grata. So there are consequences for upsetting the public good, even if you're a diplomat. And so, you know, here I mean, it makes common sense to me that you can't just visit the United States, have a child, and all of a sudden you're tethered to our country. Why would, I mean, the point of the 14th Amendment, just to bring it all the way back, isn't the whole point of the 14th Amendment to ensure that former slaves were respected as citizens of the United States?
It is. It overruled the infamous Dred Scott decision that said not only were they not citizens, but never could become citizens. The 14th Amendment addresses that directly, but it addresses it in broader language. Anybody born here to children of parents who owe allegiance to the United States and not to any foreign power are automatically citizens as well. But temporary visitors, and certainly those who are here illegally, the reason this is so important, it goes right to the heart of consent of the governed. We've never consented to make Chinese birth tourists or Russian birth tourists in Miami citizens. And yet, by this false interpretation of the 14th Amendment, they're able to demand citizenship without our consent. It's a violation of the very core principle of consent of the governed in the Declaration of Independence.
What has the Supreme Court said on this subject? There's a lot of I've noticed a lot of people insisting, oh, the court has ruled on this. They've come down clearly that birthright citizenship is constitutional and that what Trump is doing is unconstitutional. Is it really that clear?
No, it's not at all. And look, scholars throughout the last century have acknowledged that the key Supreme Court decision dealing with this did not address the children of temporary visitors or the children of illegal immigrants. The case is the 1898 case of Wong Kim Ark, and Wong Kim Ark's parents were here permanently domiciled. The court uses that phrase 28 different times in the opinion. And if that decision had said anybody born on the U.S. soil, no matter the circumstances, are citizens, I'll go back to the point you made earlier. We wouldn't have needed the 1924 Indian Civil Citizenship Act. But the fact that we needed that act meant that the Supreme Court precedent in Wong Kim Ark meant only what was at issue, which is the children of lawful permanent residents, domiciled. Green card holders, the way we would phrase it today, are citizens. And there's some dispute whether even that was a correct decision, but it certainly didn't go any further than that.
Mm-hmm. Yeah, common sense, of course, dictates that illegal immigration into the United States does not entitle you to the privilege of creating American citizens. And vacationing here or overstaying a visa and doing the same. That's it's absurd on its face, just as a normative matter. And yet we're hearing a lot from the left today that this is a settled matter and you are not to reopen it. So the president uses this executive order this week to declare that his administration's interpretation is consistent with yours, John Eastman, that no, you can't just be illegal and have a child and that child becomes an American citizen, tethering you to the United States. How important is that executive order? And do you expect this to be litigated?
Well, there's been 3 lawsuits already filed, one in New Hampshire by the ACLU, one in Boston by about 18 states, and then one in Seattle, Washington by 4 additional states. And they're all saying the same thing. This has been settled for 150 years. And it's just a blatant lie. And so, we'll see what the lower courts, those jurisdictions appear to be cherry-picked for having fairly liberal Obama and Biden judges on the courts. And it'll go up to the courts of appeals. The Boston one will go up to the First Circuit, and the Seattle one will go up to the Ninth Circuit. And eventually this will land in the lap of the U.S. Supreme Court. And this Supreme Court is comprised of originalists, more originalists than we've had in a century. And I think we're therefore going to get a very thorough assessment of what the clause actually means. And my scholarship on this, and the late University of Texas law professor Lino Graglia's scholarship on this, Yale professor Peter Schuck, and University of Pennsylvania professor Roger Smith have all dug deeply into these issues in their scholarly research and come to the same conclusion that I have, that subject to the jurisdiction meant subject to the complete jurisdiction, not owing allegiance to any foreign power. And I think the Supreme Court, if they take seriously that scholarship and those original materials, will agree with us.
So then the next question becomes, let's assume, play out hypothetically, that the court does take all of this up and it arrives at that finding that birthright citizenship does not apply to illegal aliens. If they do that, one of the things I keep hearing the left say is that means that people will be stripped of their U.S. citizenship. In other words, the children of illegal aliens who've already been born in America, who are considered at the moment U.S. citizens, they will have their citizenship stripped away. Is that what's actually going to happen?
Well, the executive order quite clearly prevents that interpretation. It says it only applies for children born 30 days after the issuance of the executive order. And that means it's not going to touch anybody who have been falsely led to believe that they were citizens. It's going to continue to treat them as citizens. And in fact, there was a bill introduced in Congress just last night that says the same thing. It doesn't look backwards at anybody that we have been falsely treating as if they were already citizens. Mm-hmm. And I hope that bill ends up saying, and in fact, under Congress's power over naturalization, we're going to make them citizens back, retroactively to remove any ambiguity. people that have come in to rely on this false understanding of citizenship shouldn't have the rug pulled out from under them. And President Trump's executive order doesn't do that. It's forward-looking only.
Finally, I'm reminded, John Eastman, of I've been watching some of the coverage of this debate, and I saw Alan Dershowitz talking about it, and he had suggested that perhaps Congress should pass a piece of legislation that is explicit about the definition of, quote, end subject to the jurisdiction thereof. Congress would lay out what that means specifically. Do you think that's advisable? Is that a good idea?
I think it is a good idea, and that's exactly the bill that was introduced last night by Representative Brian Bilbar, I think is his name, and joined with about 24 co-sponsors. And similar bills like that have been introduced for, quite often over the last 20, 25 years. I think this one finally has a chance to pass.
We'll see. Well, thank you very much for your wisdom, John Eastman. Always good to talk to you, sir. Really appreciate it today.
Thank you very much. I appreciate it.
All right, John Eastman with the Claremont Institute, a former attorney for President Trump as well.